going to ask our instructor today, Kerstin Henze from our Tampa location, to start your feed. There she is. Good morning. How are things in Tampa today?
Hello.
How was the
Very
traffic?
warm over
How's
here.
getting in? Everything good?
Everything's good.
All right. So Kerstin is our managing attorney of the Tampa location, also a firm member, recently moved to the location. Kerstin, please introduce yourself a little bit further than I already have. And we see your email addresses on the screen so people know how to contact you. But tell us a little bit more
Sure.
about yourself and the Tampa location as I get the slides ready.
Hello, everyone. So I'm Kerstin Henze. I am the firm member and managing attorney of the KBR office here in Hillsborough County, which is actually located in Tampa. So I have been with the firm since 2010, exclusively practicing community association law for going on 14 years. So, and 15 years in total of
You started
practicing
when you were
law.
13, right?
So, essentially,
Yeah.
I am much older than I look.
Fun. Well, you ready to get started? I'll get the screen share going and we can get the course going for these fine folks here today.
Do it.
All right, here we are. Here is our title screen, and Kerstin, the floor is all yours. Take it away.
All right. You want to move to the next screen?
Let's do it.
All right. All right. So this class is about an hour. I don't know that I will be talking for a whole hour, but I'll try to get through most of the material as quickly as I can, and then I'll certainly stick around for some questions. Okay. All right, so we're talking about amending your governing documents. So a good place to start is, what are your governing documents, right? And the hierarchy. So your governing documents will consist, and this is for condos as well as for HOAs, your documents will consist of your declaration of condominium or your declaration of covenants, your articles of incorporation, and your bylaws. Okay, those are the governing documents. Rules and regulations are not considered part of your governing documents. For Chapter 720, which governs homeowner associations, a few years back, the statute defined the term governing documents to include rules and regulations. That has since been amended from Chapter 720. So rules and regulations are no longer considered part of the governing documents. Okay, and in terms of hierarchy, your declaration of condominium or your declaration of covenants, that is going to be your supreme document here, okay? It's your constitution, it is your contract between the association and the owners that buy into the community, okay? And it is the document that's going to contain your use restrictions, what you can, what you cannot do. It will address issues like maintenance, who's responsible for what in a condominium or in a homeowner's community. It will address material alterations, changes, etc. That's in your declaration. The next document is going to be your articles of incorporation. Okay, articles and bylaws, those will typically address the corporate governance of your association. Your association is a non-for-profit corporation that's governed under Chapter 617 of the Florida statute. Okay, and in order to operate, in order to exist, it needed to have filed articles of incorporation with the Division of Corporation in Tallahassee. Okay, so that is your articles of incorporation, and it will address things like, who are the directors, who qualifies as a member, how many directors you can have on the board, elections, who are the initial incorporators of the entity, etc. And the bylaws really is almost a little bit of an extension of the articles of incorporation. So it will have generally the basics of what the articles have and might even expand a little bit more. So what you don't want is a conflict between the articles of incorporation and your bylaws. So for example, the articles will typically say a board of directors shall consist of no more than 3 directors. Okay, or it can say the board of directors shall consist of 5 directors. and then your bylaws might have something different, or your articles might say, you know, in order to qualify, in order to serve as a board member, you need to be an owner. But then maybe your bylaws do not have that requirement or might have something different. So you always want to make sure that your articles and your bylaws are consistent with one another, especially when you're amending. And if there is a conflict, you want to remove that conflict, which might require an amendment to your articles or your bylaws or both. Okay, so that's just an overview of what your governing documents are. All right, moving on. All right, so now we'll talk generally about the amendment process. So typically, amendments to your governing documents can be approved by the membership either at a meeting, and that could be either your annual membership meeting, or you can have a special membership meeting just for the sole purpose of owners approving amendments, or you might want to present the amendments to the owners by the written consent process in lieu of a membership meeting. That's the alternate to approving amendments at a meeting. So with the written consent process, if you're in a condominium, you have to have specific authority in your governing documents, specifically in your bylaws, to allow owners to approve amendments by the written consent process, or really generally just for owners to take action by the written consent process. With HOAs, as long as your bylaws don't specifically prohibit amendment through the written consent process or just taking action by the written consent process, then members can do so, okay? And with the written consent process, really it's you'll prepare a consent form that identifies the amendment that you want owners to approve, and you'll mail that out along with a proposed amendment. And those owners that approve the amendment will just have to sign the consent form and return it. And that will take place in lieu of having to conduct a membership meeting. Now, those consent forms, as soon as you receive the first executed consent form, you have 90 days from that date in order to get the requisite consent forms that you need to pass the amendment, okay? So it's 90 days from the day that you receive the written consent form. Now, if you're going to present the amendments to the membership at a meeting, then you might mail out a proxy with your amendment. So proxies go along with the membership meeting. And in case of amendments, you will be sending out a limited proxy as opposed to a general proxy. And you might have to get with your legal counsel or your management company to prepare that specific limited proxy. It has to identify the specific amendment, the language of the specific amendment that you want them, the owners, to approve. Now, with proxies, they're good for 90 days from the date of the first membership meeting. Okay, so if you hold a membership meeting, let's say January 1st, okay, and you don't get enough proxies or ballots on the amendment, those limited proxies are still good for 90 days from that first meeting, January 1st. So what that means is that you can recess and reconvene that membership meeting as many times as you need to, up to that 90th day deadline, in order to get the votes that you need. And you might need to, you know, knock on doors, but it gives you that flexibility, okay? Once you adjourn a meeting, then that proxy is not good anymore, okay? So again, if you still need to get more votes, okay, then recess and reconvene the membership meeting so that your proxy is still good, because once you adjourn the meeting, that proxy is no longer valid and you'll have to start the amendment process again. Okay, distribution to members. That has to do with how you have to present the amendments to the members. Both under the condo and the HOA statute, when you draft amendments, you have to indicate what the changes are. So any words that you're adding, the statute says you have to underline. Any words that you're deleting, the statute says you have to put a strike through across that word, okay? Now, the statute does say that if you are making substantial changes to the amendments, and that's going to hinder the understanding of the members as to what you're trying to accomplish here, then you have the option, instead of underlining and striking through the changes, to indicate at the top of the amendment, substantial rewarding, please refer to the original document for the original text. That is an option. Now, whether you want to do that or do the underlines and strike throughs, that's something you might want to check with your legal counsel. Vote tally. Okay, that has to do with the percentage of votes that you will need to get the amendments passed. So each document, your deck, your declaration, your bylaws, and your articles of incorporation is going to contain an amendment section that identifies the percentage that you need in order to pass an amendment, okay? So you have to look at the document you're trying to amend to see what that percentage is, okay? It's going to be very specific to that particular document. Now, if your documents are silent, then under the condominium statute and the HOA statute, the vote that you'll need to get an amendment is 2/3 of the membership. So check the voting percentage required in the documents, but if they're silent, the vote that you need is 2/3 of the voting interest. Now, for many communities, 2/3 is a lot. And you might even have something that you might have documents that require the approval of 75% of the membership, which might be too much. So in that case, what we typically recommend clients is try to see if you can first amend your governing documents to reduce that voting percentage to something that's a little bit more manageable, like a majority of the owners. And then once you get that amendment approved and recorded in the public records, then try to tackle the more substantive amendments. Okay, so that's often a good option for communities that have a high voting percentage requirement. Now, this amendment percentage that I just discussed, that's generally going to be the case for most amendments. Okay. Now, there are amendments which are considered material amendments. Okay. Those amendments, for example, could be if you wanted to change the percentage of assessments that owners pay, or if you wanted to change the percentage of the common elements that owners own. Those are considered material amendments. And typically, under the statute and governing documents, these types of amendments will require a much higher threshold. Typically, they require the approval of 100% of the homeowners, including mortgagees, which is why these types of issues are typically not amended, okay? Now, leasing restrictions, excuse me. If you're in a condominium, Chapter 718 has a restriction in the statute. It's actually in the statute that says, if you are going to amend your governing documents to either prohibit leasing or reduce the term of the lease or limit the number of times that an owner can lease in the community, those types of amendments are only valid against those owners that vote in favor of those amendments and those owners that take title after the effective date of the amendment. If I haven't mentioned this already, an amendment is only effective after it's recorded in the public records. So it's not when the membership approved it, it's when the amendment is recorded in the public records of the county where the condominium or the community association is located, okay? So with lease amendments for condominiums, again, they're only valid against those owners who vote in favor and those owners that take title after the amendment is recorded in the public records. That means that specifically with lease amendments, you will want to be careful in tallying the votes and making sure you notate in your documents, in your records, who voted for, who voted against, because that's going to become important at the time of enforcement. So when you try to enforce a lease amendment, that prohibits leasing or limits the term or the number of times you can lease, if you're trying to enforce that against an owner who voted against the amendment or who didn't vote for the amendment, okay, that owner can then have a potential defense and could say, well, this amendment does not apply to me because I didn't vote for it. Okay, that's how that would play out. Now, HOAs in 2021, the law changed to include a similar restriction in the statute. So again, for HOAs, now if you were to amend your documents to prohibit leasing or limit the term or limit the number of times that a homeowner can lease, again, that's only going to apply to those homeowners who vote in favor of that amendment and those owners that take title after the effective date of the amendment, after the amendment was recorded. Now, the statute, the HOA statute, does allow you to amend in order to prohibit leasing for less than 6 months or more than 3 times. If you do that type of amendment, prohibit leasing for less than 6 months or more than 3 times in a year, then that would apply to all owners. You know, regardless whether you approved it or disapproved it, as long as you get the necessary membership approval requirement that's required in your documents, it will apply to everybody. Okay. Suspension of voting rights. You know, this could be an effective tool in trying to get an amendment passed. Because if you suspend the voting rights of an owner, then that unit, that lot basically will not be counted towards quorum and will not be counted towards the number of votes that you will need to get an amendment passed. Okay, so for example, if you have 100 units or 100 lots in the community and you suspend the voting rights of 10 owners, then now you would need to get the approval, not of 100, but the approval of, you know, whatever your percentage required in the documents of the 90. Okay. Now, for homeowners association under Chapter 720, you can suspend voting rights of those owners who are more than 90 days delinquent on any monetary obligation owed to the association, and that would include, you know, your assessments, interest, late fees, or even fines. Okay. For condominiums under 718, you can suspend the voting rights of owners who are delinquent on any monetary obligation that is more than $1,000, and you must also be delinquent for more than 90 days. So the condominium statute has a monetary threshold. The delinquency has to be at least $1,000 or more, and again, also 90 days delinquent. Now, it's quite possible that your governing documents might require mortgagee approval. So depending on the type of amendment that you want to undertake here, you might be required to get the approval of mortgagees, and that's going to be specific to your governing documents. Okay, so if you are required to get the approval of mortgagees, okay, then both 718 and 720, Chapter 718 and Chapter 720, outline the statutory process of obtaining mortgagee consent. And typically what that will entail is having to undertake a title search of all the lots or units in your community to confirm who has a first mortgage, notifying then those mortgagees, sending them a copy of the proposed amendment. And typically the approval is done by a negative notice process. It's basically where you send them a letter saying, hey, this is the proposed amendment that we're seeking to get approved. The members have already approved it. If you have any objections, let us know in the next 60 days. Otherwise, if we don't hear from you, your consent is presumed. And then you can go ahead and record the amendment in the public records. But again, mortgagee approval requirements is going to be very specific to your governing documents. Okay. All right, true or false, common misconceptions. So the next few slides, what we're going to talk about are common amendments or common points, issues that typically you'd want to look at your governing documents to see if these issues need to be addressed, amended, modified, okay?
Yeah.
Obviously, you might have other issues specific to your community that you might want to amend. Definitely speak to your legal counsel. If you don't have one, we're certainly available to assist. But these are just some of the common points that you want to check your governing documents and you might want to consider amending. So, what provisions are illegal? Typically you want to make sure that whatever amendment you propose does not discriminate or runs afoul of Fair Housing Act. Okay. Other than that, as long as you're not being discriminatory, okay, generally speaking, most amendments to governing documents, as long as they're approved in accordance with the procedures in your governing documents, then they should be enforceable. Okay. Owners, when they buy into a condominium or a community that's governed under an HOA, they buy with the understanding that governing documents can be amended and they will be bound by those amendments. Okay. Now, what provisions are holding you back or costing you money? That's something for the board to discuss, and certainly with your legal counsel. Maybe you have, a really high voting percentage requirement. Maybe you have apathy in the community that's, in the way of getting amendments passed. Certainly discuss with your property manager and legal counsel, what these issues are and how they can potentially be overcome so you can get those amendments passed. Okay, Jeff? All right, so First Amendment. A foreclosing lender, and we're talking about first mortgagees, is a foreclosing lender required to pay 1% of the original mortgage debt or 12 months of delinquent assessments. This is commonly known as the safe harbor rule. Are first mortgagees required to pay this? Well, false. That is definitely what the statute says. That's what 718 and 720 says. However, this is not guaranteed. This is where you want to look to your governing documents, and many of the older governing documents, okay, may have language, okay, that provides mortgagees greater protection. So we've typically seen in older governing documents language that would say, a first mortgagee that takes title to unit through foreclosure or a deed in lieu of foreclosure is not liable to pay any assessments that accrued up to the point the mortgagee took title. Okay, and based on recent case law, first mortgagees have been successful in using language in the governing documents to avoid having to pay assessments. Okay, so go to your declaration. This is something that would be contained in your declaration, typically in the assessment section. So check it out, see if you have language that gives mortgagees, and sometimes the language might even give protection to third-party purchasers. So a third party that takes title at a lender foreclosure, you might have language that says they're not liable for anything, whereas under the statute, they are liable, jointly and severally liable with the owner. If you have that language, you will definitely want to amend, okay, to at the very minimum say that the mortgagee and third-party purchaser are going to be liable for whatever amounts are set forth in the statute. Okay, next slide. All right, all new owners must go through the screening process in your community. That's false. I know a lot of communities, a lot of board of directors, want to screen, buyers, but whether you have the authority to do so or not in your governing documents will completely depend on your documents. Okay, this is not something that's governed under the statute. Just because you're a community association, you automatically have that right to screen new buyers. That is not the case. It's going to be very specific to your governing documents. If you don't have the express authority in your declaration to approve, disapprove buyers, you may want to have it. Okay, then speak to your legal counsel about amending your documents to give you that authority. It's not, a simple amendment as, one sentence. The board hereby has the authority to approve or disapprove buyers. There has to be very specific language, in that amendment in order for that authority to be valid. Specifically, there has to be language of right of first refusal. I'm sure a lot of you have heard of that very confusing term. We do teach another course that addresses, the screening process, but I'll generally just mention here, under Florida law, in order for the association to have the authority to approve, disapprove buyers in a sale, purchase transaction, the association has to have a corresponding obligation to exercise a right of first refusal and provide an alternate purchaser when the association disapproves for reasons other than good cause. So one of the things that your amendment needs to include is that right of first refusal language. And you will want to also identify the good cause criteria upon which the board can disapprove a purchaser. So a good cause could be, negative criminal history, negative financial history. You'd want to have that specifically in your declaration. Okay, so only if you disapprove for reasons other than good cause will you then need to exercise the right of first refusal. But if you don't have that language, that amendment is essentially not good and could subject the association to legal challenge. Okay, so you want to get together with your legal counsel to properly draft the language for sale approvals. Same goes with leasing. If you don't currently have the authority or the ability to approve, disapprove leases, you might want to amend your documents to include that authority. There are other transactions that you might want to approve in addition to sale purchases. Maybe gift transactions. If an owner wants to quitclaim convey deed by quitclaim to a spouse or add someone else onto the deed. Do you want to have the ability to approve, disapprove those types of transactions? If you do, that's something that you'd want to amend your governing documents to include. You might, if you do have the ability to approve and disapprove sales or other transactions or leases, look at your governing documents. You might have language that, for example, says, once a mortgagee takes title to a unit or a lot, they can they can sell the unit or they can lease the unit without that applicant, without that individual going through the approval process. Do you want those individuals to be exempt from the approval process? I can tell you most clients that we represent do not. That's something that you will need to amend to remove that exemption. You might have other exemptions in your approval, in the approval section of your documents. Maybe, spouses or children or other immediate family members are exempt from approval. Let's say you have an owner who's single and then later on wants to add a spouse to the deed. Do you want that spouse to also go through the approval process or not? These are things that you'd have to discuss internally with the board members and, legal counsel on how to properly draft that language. Okay, moving on. Once the law changes, the change is automatically applicable to your community. Is that true? That is false. That's not the case. This has to do with Kaufman language. Many of you have probably, heard that term. Okay, that arises out of case law, and it basically refers to the magic words of amended from time to time that you will typically see after a reference to either Chapter 718 or Chapter 720 of the Florida Statute. So if you open up your declaration, it'll typically be in your declaration. Somewhere on the first or second page, you might find language that says, this community or this condominium is subject to and construed under the laws of Chapter 718 or Chapter 720 as amended from time to time. Okay, that's Kaufman language. Most of the older documents from the 70s and 80s do not typically have that language. Okay, typically when I do see that language, it's because it's been added there by amendment. Okay, now what is the implication of this Kaufman language? Well, if you have Kaufman language, then that means that all changes to 718 and 720 will automatically apply to your governing documents and your community without having to amend them. Okay, so in the case of the lease restrictions that I just mentioned for 718 and 720, the ones that says that, if you amend your documents to prohibit leasing, they would only apply to owners that vote in favor and those that take title after the effective date of the amendment. Well, if you have Kaufman language in your document as amended from time to time, then that change in the statute would apply to your community and you'd have to, abide by that. What if you don't have Kaufman language? You don't have amended from time to time in your declaration. Well, what that means is that, generally procedural changes to the statute will apply, but substantive changes to the statute will not. Now, this is a very complex area of the law, and I'm very much simplifying here, okay? But procedural changes, okay, would be, for example, a change in the voting process, okay? So, 718 and 720 addressed, voting, or, for example, a change to the election process. Both statutes address elections. And let's say 718, there's a change in 718 that, requires a third notice before an election is held, or, might reduce the time frame of sending the first or second notice. Okay, those are procedural changes to the statute, and they will apply to your governing documents and your community, regardless of whether you have Kaufman language or not. Okay, so if there is that type of change, you will just follow whatever the changes in the statute, and you'll have to abide by the new voting requirements or the new election requirements, okay? But if you don't have Kaufman language, then substantive changes to the statute, and substantive changes are those that affect the vested rights of owners. Those changes would not apply to your governing documents, or you can at least make the constitutional argument that they do not apply. And, really the basis of that is that, the government can't retroactively impair contractual rights. Okay, so the legislature can't just adopt a law that now retroactively, impairs a contract that existed before the law. And as I mentioned earlier on, your declaration is a contract. It's a contract between the owners that buy into the community and the association. So the constitutional argument, if you don't have the Kaufman language in your documents, is that, well, this new change in the statute, let's take the example of the lease restriction. This lease restriction doesn't apply to our declaration, to our community, because you can't just change existing rights under our current declaration. We don't have that Kaufman language, okay? So in that case, the argument is that the law that was in effect at the time that the declaration was recorded, that is the law that would apply. Now, unfortunately, we haven't had any clients that have tried to make that constitutional argument in court. So, presently, there's really no precedence on this particular issue. So whether you want to include Kaufman language in your governing documents, if you don't currently have, that is something that you really need to speak to your legal counsel. And it's probably going to be on a case-by-case basis, okay? So very complicated concept. Speak to your legal counsel if that's the best thing for your documents and community. Okay. The board must obtain a vote of the owners before making a material alteration. Okay, well, that's not generally true either. Okay, for condominiums, the statute does say that unless otherwise provided in the declaration, the vote that you need is 75% of the membership, 75% of the voting interest to approve a material alteration to the condominium. But check your governing documents. Again, you might already have a voting percentage. It could be 75%, it could be 75% of quorum, it could be 2/3, it could be a majority, whatever it is. For condominiums, that's the voting percentage that you would have to follow for material alterations. For HOAs, Chapter 720 does not address alterations like 718 does, okay? That's going to be also very document specific. You might also have in your document, a threshold requirement. You have to spend a certain amount of money before triggering that membership approval. So something like, the board can spend up to, 25% of the budget on an alteration or material alteration or capital improvement. And anything, beyond, 25% of the budget might require the will require the approval of a majority of the owners. So you might have that language. And if you don't, okay, then that's probably, a point of amendment. That's something you might want to then amend, whether it's adding a threshold requirement or maybe even reducing the voting percentage required for material alterations. But also be aware that there is case law out there that says that if the association is undertaking a necessary maintenance obligation, that could be an exception to your material alteration vote. Okay, now that is very, specific. So that's something that you will also want to get together with your legal counsel to confirm whether in fact you do need a membership vote in light of, whatever project it is that you're undertaking. Okay. All right. Delinquent assessments accrue interest at the rate of 18% and a 25 late fee applies. Okay, that's not exactly, true. That doesn't necessarily apply to your community. For late fees, in order for the association to be able, and this is both, HOAs and condominiums, in order for you to be able to charge a late fee, okay, you have to have the authority in your declaration or in your bylaws. And then the maximum amount that you can charge on a late fee for a delinquent assessment is the greater of 25%. I mean, at $25 or 5% of the delinquent assessment. But again, you have to have the authority in your governing documents to be able to collect that late fee. It's not automatic. For interest, if you're a condominium, then interest can be charged at the rate that's provided in your declaration. And if you're an HOA, again, interest can also be charged at the rate that's provided either in your declaration or in your bylaws. So it's not an automatic 18%. If your documents are silent, then yes, 18%. But many documents already include a certain percentage, 10% or 15%. So check your documents. If you have, if you have the ability to collect interest at a rate that's less than 18%, then you want to amend your governing documents. And what we typically recommend to our clients is language that gives you the ability to collect interest and late fees at the highest rate permitted by law. If you add that language in your amendment, okay, then every time the statute changes, the rate will just automatically adjust to the maximum that's provided in your statute, and you don't have to go back and amend your declaration or your bylaws every time, necessitating a vote of the membership. Okay. All right. If a pipe in a wall only provides service to one unit, that unit owner is responsible for maintenance. Well, sometimes that could be true, sometimes that could be false. That is really document specific. Really, this applies to all maintenance issues. These are document specific issues. So you want to check with your governing documents to see who's responsible for what. You'd be surprised how many board members think that owners are responsible for maintaining certain things, but come to find out it's really the association's maintenance responsibility, or vice versa. Okay, so check your documents. Just confirm that they address the way you currently operate. And if not, if the association has been maintaining, certain types of pipes or conduits for years, and that is how the board prefers to do things, but the documents say something different, then that's an area that you might want to amend to accurately reflect how you currently operate. Or vice versa, things have changed, you might want to shift maintenance responsibilities from one party to another. Okay, that's another area of amendment. Check your governing documents. You might have language in there that require the association to be liable for incidental damage when you undertake certain maintenance of common elements. So for example, if you are required to maintain a common element pipe that is behind a drywall, and you have to, make a hole in that drywall to get into that pipe, but you also have to cut out, a portion of a backsplash in the kitchen in order to get to that pipe. Check your documents. If you have incidental damage, you, the association, might be liable for the damage to the backsplash. Okay, so that is an area that you might want to amend out of your governing documents. Or you might actually want to put something like that in your governing documents. That is very specific to your community. Check the documents to see if you have self-help remedy. Okay, self-help remedy is if an owner is responsible to undertake certain maintenance, and that applies both to condominiums and HOAs. If an owner is supposed to, mow the lawn or maintain, some part of the unit, and they fail to do that, if you have self-help remedy in your documents, then that language will give the board the option, the authority to undertake the maintenance responsibility of the owner, and possibly even charge the owner for the cost and lien and foreclose. A big caution, recent case law has come out and said, and I'm simplifying this, but essentially, if you confirm, or if your legal counsel confirms that you have this self-help remedy, okay, under recent case law, the association now has to exercise the self-help remedy. In other words, go and undertake the owner's maintenance responsibility before you can file, further legal action against the owner to force the owner to do that maintenance. So if the owner hasn't been mowing their lawn and you have the option to exercise self-help, even if it's an option, the fact that it's in your governing documents, okay, now means that you have to go and try to mow the owner's lawn before you can file, a lawsuit against the owner, or before you can file legal action against the owner to force the owner to correct that. Okay, so what that means, if you do have self-help remedy, this might be a topic you want to discuss with your legal counsel to see if you want to amend that out of your governing documents. Okay. So what have we learned today? I mean, we've learned a lot. But again, these are some of the more common issues that we've seen that typically require revisiting your governing documents and potentially drafting amendments to change. You might have other issues, again, that you might want to tackle, sales, leasing, pets, commercial vehicles restrictions, or any other type of vehicle restrictions. All those items need to be amended into your governing documents to be enforceable. Okay. And, for some of you who have older documents, you might be at a point where instead of tackling, certain amendments, it might just make sense to do an overhaul of all of your governing documents, okay, of your declaration, your articles and bylaws, and not only bring them basically up to current law, but address some of the more substantive changes applicable to your community in that document review process. So, again, something to discuss with your legal counsel. If you don't have one, then we're certainly available to help you with not only, very specific amendments, but certainly the more comprehensive document review and rewrite process. So with that said, now some fun. Healthcare alert. Owning a home in an HOA may be hazardous to your health. And if not, it can certainly give you some gray hairs. Because I've certainly gotten a few gray hairs practicing in this area of the law.
I was about to say we know nothing about that, but you just made a
That
liar.
concludes this presentation, but I'll certainly stick around and try to answer some questions.
So that's great. What I'm going to do, great job, Kerstin. I'm going to enable the Q&A. Folks, keep in mind, we're not going to get to all of them. There's still over 250 of you here. So I'm going to enable the Q&A. Please don't keep it specific to your association. We don't know your documents, nor should any of this be considered as legal advice. Okay, this is informational and educational only. And I'm going to enable the Q&A. Kerstin, you go through the Q&A while I one more time go through the evaluation process. I'm going to share the screen while you're looking at the Q&A. I'll enable that now so you can see it. And okay, folks, Q&A is now enabled. You can type in some questions. We'll answer a few of them. We don't have a lot of time left. And while the Q&A is populating, I'm going to share the screen one more time. Folks, in the chat area, not the Q&A area, the chat area is different. I placed a link into it. That link takes you to this screen that I am sharing right now. And this is what you fill out to help prove that you were here the entire time. We also have the Zoom attendance sheet for Cam so we can see who will get the credit that was here for the duration. Fill it out, you hit submit. After you hit submit, the confirmation screen looks something like this. In this shaded area, it says click here for the slides. Click on that. A new tab will open up. You can then go ahead and print or save those. I recommend saving them. We have some color in here, and that's going to be a toner and ink killer for your printer. So go ahead and download them and save them. That's what I would do, or print them. And underneath it, you could also print this certificate by clicking on this link. Click on that, and a printer dialog box opens up. You can go ahead and choose your printer and print it that way if you choose. I'll go over that process again one final time after the Q&A. You do not need to stay for the Q&A if you need CAM credit. We want you to. We would love for you to, but you do not need to. That part is not required. So let me stop the screen share. Kerstin, you could address some of the questions that are in there now. The floor is once again yours. Thank you.
All right. Let's see. A question here from, I think, Shroy. Our building is getting taken over by investors. What can we do? Lots of apathy in the membership. I mean, certainly,
I bet you Airbnb goes hand in hand with that too. Investors renting the whole thing, right?
Sure. I mean, if investors, you mean individuals, well, really could be more entities than individuals. Certainly you can, one option is to amend your docs to prohibit entities from acquiring title in your community. And entities could be, corporations, or, more often than not, limited liability companies, because those tend to be for, they usually buy for investment purposes.
Right.
So that's one option, and that amendment can certainly would have to exempt first mortgagees that take title through foreclosure because they're entitled to foreclose on their mortgage, and should exempt the association because the association is an entity but can certainly foreclose and lien and foreclose for delinquent assessments. Okay.
Yeah.
Other options, I mean, definitely, put something in your documents regarding Airbnbs, limiting the terms. But again, depending on, the language of your documents, you have Kaufman language or not, certain types of, lease amendments, might not apply to owners that didn't vote or, voted against the amendment. So you've got that caveat there.
Yeah.
Let's see, from Gretchen, is there generic language that is standard for all documents? I mean, some language could be, standard. Typically it's in the opening part of the your declaration, but really, use restrictions and how you want to operate is going to be very specific to your community.
Let me ask you this. One way that question could be interpreted is maybe if there's something in the documents that's not in there. Okay. And hear me out. I know she's saying generic, but let's say there's something that's not in the documents, but an issue arises. That particular issue happens to be in the statute as it pertains to condos or HOAs. They would then have to follow that generic, so to speak, language that's in the law, correct? If it's not in their specific documents. Because it could be looked at that way too, right?
Typically, yeah, that's a more complicated analysis. Again,
Right.
that goes in, hand in hand with Kaufman. So
leave it to me to make it complicated,
Yeah. Let's see.
I mean, yeah, no, I'm kidding.
If your bylaws state authority to approve or disapprove owner's tenants, but the declaration is silent, can you still screen? This is for 718. Yeah, typically not. First of all, you want to have these use restrictions in your declaration, not in your bylaws, but also specifically with approving, disapproving purchasers. It can't be just the one sentence that says, the board has the authority to approve or disapprove. You have to have certain language addressing right of first refusal and the requirement for the association to provide an alternate purchaser when it disapproves for reasons other than good cause. So it is a much more involved amendment than just, a one statement that you have the authority. So get with legal counsel on that.
And Gloria, thanks for that question, Gloria Fenster. Put that into the evaluation that you would like Kerstin to contact you about your question about the procedure on amending documents if you did some work with us. Back to you, Kerstin.
Did you say rules and regs for a condo is not part of the governing documents, and what are the implications of that? Correct. So rules and regs are not part of the governing documents. Rules and regs are what they are. They're rules and regulations. Now, for rules to be enforceable in Florida, one of the rules is not one of the prongs, okay, that the rule would have to pass is number one, you have to have the authority. The board has to have the authority to adopt that rule, okay, whether it's concerning use of common elements or use of the unit. You have to have authority in your governing documents. Typically, you'll find that in the bylaws that, you might have something that says, and the board can adopt from time to time rules and regulations, okay, so that's your authority. But the second thing is that the rule cannot conflict with the declaration. Okay, whether it's a conflict by implication or a conflict with an express provision in the declaration. So, for example, if your documents prohibit, allow pets, and now you adopt a rule that says no pets allowed, obviously there's a conflict, right? Because your deck specifically says pets are allowed, but you might have to make sure that you walk them on a leash or whatever the case might be. There's a conflict, okay? If you were to enforce that rule, it would likely be legally challenged and the association might lose. But let's say your documents are silent on pets, and then you go ahead and you adopt a rule that says no pets allowed, okay? the implication here is that because the documents didn't specifically address pets, pets are allowed. And so now you have a rule that again conflicts with the declaration. And so if you were to enforce that rule, you might not be successful. Okay, so when you adopt rules, you just have to make sure they work hand in hand with use restrictions you already have in your declaration so they don't conflict. Okay.
While you're looking, Daniel, you said chat is disabled. It is disabled towards us. We can send stuff out to you. So the link is in the chat area. And when Kerstin is done with the next couple of questions, I'll enable the chat for you to contact towards us, where I will answer technical questions on the evaluation, not attorney-related questions. I only play an attorney on TV. Back to you.
What is the best way, from Penelope, what is the best way to initiate review or updating documents? Do you start with attorney review or set up a committee to try to see what needs change? I mean, I think a little bit of both. I mean, you could definitely start a committee to, put a list of items that you want to address. You might even survey the community to see, what their take is on these particular issues to get a sense of whether, these changes might pass or not. I can tell you from, my personal experience when a client wants to undertake a document review, I certainly welcome a list of proposed changes, but I do not recommend a board to attempt to draft the changes. It's way more cost effective for me personally to draft the changes after we've talked about what your needs are than for me to try to read what you've drafted and then deconstruct and then put it together correctly. So but that's my personal opinion.
One more. Excuse me. And folks,
a lot of very specific questions
yeah,
about housing for older persons that not necessarily are the topic of this seminar.
And while Kerstin's going through some of the questions, folks, when she's done with this final question that we're looking at, I'll stay on one more time to more slowly go over. I know I tend to rush through it, the evaluation process. So hang out with me after Kerstin takes this last question.
Last question. Do rules and regs need to be drafted by an attorney? I mean, they don't have to be drafted by the attorney, but once the board comes up with their rules, I definitely recommend the attorney to review the rules, because again, the attorney can then give you guidance on whether there's any conflict with your declaration. We certainly, do those rule reviews for clients all the time. So the attorney will be able to point out if there's a conflict with the declaration, and if so, how you either need to change the rule or might recommend an amendment to the declaration to then avoid the conflict with the rule. Okay.
Outstanding.
And that's it.
Fantastic job. You had a big crowd today, so that's not easy. Thank you so much for your time. To everybody in attendance. Kerstin, thank you for your time.
Thank you so much for attending on a Friday, just before lunch too.
That's why we do it earlier. I think we do this at 2:00. We don't have the big crowd. And I know we have your email on the screen, but what are some other ways people can contact you, Kerstin? Of course, they're going to, if they want contact, folks in the evaluation, you can request contact from Kerstin or anybody.
Yeah, that's definitely probably the best, quickest way right now. If you want me to contact you about potential representation, or if you have any other specific questions, I'm happy to give you a call, follow up by email. You can certainly reach us by phone. We have one main number, 954-928-0680. You call that number and receptionist will direct you to my office here in Tampa.
Sounds wonderful. And again, thanks so much. We appreciate your time.